Hello and good day, everyone. This is Attorney Angel. Well, we are now going into the 9th week under the enhanced community quarantine, and I hope that everyone is coping well physically, mentally, emotionally, and spiritually. I know it is a struggle, and we have our own anxieties to deal with, but trust in the Lord, we will get through this. With that being said, as you all know, the Arellano University School of Law already issued guidelines on how to proceed with the rest of the semester. And you know that prior to the issuance of these guidelines and on the onset of the ECQ, we already created our Facebook group page. And through this Facebook group page, we are able to communicate and you're able to post your assignments, exercises, and other activities as well on our FB group page. And for your information, I also informed Dean Navarro that I will be recording lectures and I will be sending them to you. And also, I informed him that I will be giving written assignments and other exercises or activities to cover the rest of the topics on our syllabus. Okay. And for the midterms, we will dispense with the midterms and I will consider the infographics as part of your midterm exams. But that is only half of it. So the half or the 50% will be a recording, a video recording of you discussing the infographic that you have submitted and posted on our FB group page. And that will be a total of 100% for your midterm exams. If you have any questions on that, please feel free to send me a message through our FB group page or through private chat or messenger or through email. Email is angel.valero@umac.edu.ph. Okay. So for this lecture, we will go back to the part on our syllabus regarding the rules of construction for specific statutes, which we left off and which I assigned to you as a reading assignment. Okay, but I decided to divide this into two parts so you will not get bored and you will not have info overload. Okay, so the part 2 will be recorded next week and sent to you next week. But before we proceed, may I just ask you for a few seconds to remain silent and say your own prayer to thank God and to ask God to put a stop to COVID-19. Okay, amen. All right, then we can now proceed to today's lecture. At the beginning of the semester, we discussed lengthily about the law and the different types of laws as subjects of construction. And we said that statutory construction is used to interpret various legal instruments, including the Constitution, statutes, administrative regulations, and ordinances. Okay. So just to review, we also discussed that there are several kinds of statutes and that statutes have different parts. And we even identify the different parts of a statute. Here, we go back to statutes and we will discuss the rules of construction of these specific kinds of statutes. Okay. Including, for part 1, penal statutes, tax statutes, social legislation statutes, And for part 2, rules of court, adoption laws, local government, local autonomy, and constitutional construction. Okay. Penal statutes or penal laws. What are these? These are statutes which impose punishment for an offense committed against the state, statutes which command or prohibit certain kinds or certain acts, and certain kinds of acts and establish penalties for their violation. And you are most familiar with the statute in CRIM 1 and CRIM 2, which is the revised penal code, which is otherwise, which is Act 3815, enacted in 1930. So how are penal statutes interpreted? You remember in one of our Latin maxims or legal maxims, we discussed about nullum crimen, nullo pena sine lege. Or the direct translation, there is no crime when there is no law punishing it. Well, corollary to this is the rule of construction that penal statutes are to be liberally construed in favor of the accused and strictly against the state, meaning every reasonable doubt must be resolved in favor of the accused. However, this rule should not be unreasonably applied as to defeat the true intent and meaning of the enactment found in the language of the law. And the Supreme Court said that the language of a penal statute cannot be enlarged beyond the ordinary meaning of its terms. And only those persons, offenses, and penalties clearly included beyond any reasonable doubt will be considered within the operation of the statute. Okay. Take, for example, in the case of Centeno versus Villalon, Cornelius. Okay. This was a case about the accused being charged with violating Section 2 of PD 1564 in relation to solicitations of charitable, religious, educational institutions, etc. So here, the accused were charged of violating this section because they solicited money for the renovation of their chapel in their barrio. Okay. Let me read to you the specific provision in question. Any person, corporation, organization, or association desiring to solicit or receive contributions for charitable or public welfare purposes shall first secure a permit from the regional offices of the Department of Social Services and Development as provided in the Integrated Reorganization Plan. Upon the filing of a written application for permit in the form prescribed by the regional offices of the Department of Social Services and Development, the regional director or his duly authorized representative may, in his discretion, issue a permanent or temporary permit or disapprove the application. In the interest of the public, he may, in his discretion, renew or revoke any permit issued under Act 4075. A. The defense of the accused, they said that they are soliciting for religious purposes which do not require them to have a permit under the law or to secure a permit under the law. While on the other hand, the lower court convicted them and stated that charitable purpose is broad enough to cover religious purposes. But in this case, the Supreme Court acquitted the accused, and it held that considering PD 1564 is a penal statute, it cannot be given such broad application as would be prejudicial to the accused. And furthermore, it held that penal laws are not to be extended or enlarged by implications, intendments, analogies, or equitable considerations. They are to be strained by construction to spell out a new offense enlarge the field of crime, or multiply felonies. The principle is that acts in and of themselves innocent and lawful cannot be held to be criminal unless there is a clear and unequivocal expression of the legislative intent to make them such. Okay. Yet in another case, in U.S. versus Gochico, where the accused was charged with violating Section 1 of Act Number 1696, which is on the use of any flag, banner, emblem, or device to instigate insurrection and the like. Let me read to you Section 1 of Act 1696, which is in contention in this case. Any person who shall expose or cause or permit to be exposed to public view on his own premises, or who shall expose or cause to be exposed to public view either on his own premises or elsewhere, any flag, banner, emblem, or device used during the late insurrection in the Philippine Islands to designate or identify those in armed rebellion against the United States, or any flag, banner, emblem, or device used or adopted at any time by the public enemies of the United States in the Philippines for the purpose of public disorder or of rebellion or insurrection against the authority of the United States in the Philippine Islands, or any flag, banner, emblem, or device of the Katipunan Society, or which is commonly known as such, shall be punished by a fine of not less than 500 pesos or more than 5,000 pesos, or by imprisonment for not less than 3 months nor more than 5 years, or by both such fine and imprisonment in the discretion of the court. Here the accused was caught displaying in his store a number of medallions with pictures of Emilio Aguinaldo and the duplicate flag banner used during the insurrection in the country against the United States. And the defense of the accused was that the provision refers to display of any flag, emblem, or device used during the late insurrection, and that the law punishes the use of identical banners, devices, or emblems actually used during the Philippine insurrection and not the duplicate of those banners. Okay, here, unlike in Centeno versus Villalon Cornelius, the Supreme Court convicted the accused, upheld the conviction of the accused. And it held that notwithstanding the rule that penal statutes must be strictly construed, the intention of the lawmakers must govern in the construction of penal statutes. That though penal statutes are to be construed strictly, they are not to be construed so strictly as to defeat the obvious purpose of the legislature. Okay. Now we go to tax laws or tax statutes. These are statutes which impose rules and regulations related to taxation or to the creation of particular sources of revenue, such as taxes, fees, and charges that are needed for the support of government and for all public needs. Okay. The rule is that in case of doubt, statutes levying taxes and duties are to be construed most strongly against the government and in favor of the subjects or citizens because burdens are imposed in tax statutes, and burdens are not to be imposed nor presumed to be imposed beyond what statutes expressly and clearly import. Thus, a statute will not be construed as imposing a tax unless it does so clearly, expressly, and unambiguously. So a tax cannot be imposed without clear and express words for that purpose. Again, tax statutes are construed strictly against the taxing power and liberally in favor of the taxpayer because tax laws seek to impose burdens upon persons and property. Okay. In addition, these following rules apply to tax statutes or tax laws as well. Okay. The real purpose of the legislature, if that purpose is discernible from its statute, will prevail over the literal import of the words used. Next, the spirit rather than the letter of an ordinance determines the construction thereof, and the court looks less to its words and more to the context, subject matter, consequence, and effect. Next, the history of the statute should be considered as an aid in the ascertainment of the intention of the legislature. Okay. But when it comes to tax exemptions are construed strictly against taxpayers and in favor of the taxing power. Moreover, exemptions cannot be claimed unless they are expressly provided for in the law. The rule that tax exemption is strictly construed against the taxpayer does not apply when Congress grants a tax exemption in favor of a national government instrumentality. This was laid down in the case of PRA versus the city of Parañaque. In this case, the city of Parañaque wanted to tax the Philippine Reclamation Authority or PRA with real property tax. And it was the contention of PRA that they are part of the instrumentality of the national government, and hence they're exempt from taxation, real property tax, under sections 234A and 133O of the Local Government Code. Let me read to you the provisions in the Local Government Code. Exemptions from real property tax. The following are exempted from payment of the real property tax. Real property owned by the Republic of the Philippines or any of its political subdivisions, except when the beneficial use thereof has been granted for consideration or otherwise to a taxable person. The other provision in the Local Government Code, common limitations on the taxing powers of local government units. Unless otherwise provided herein, the exercise of the taxing powers of provinces, cities, municipalities, and barangays shall not extend to the levy of the following. Letter O, taxes, fees, or charges of any kinds on the national government, its agencies and instrumentalities, and local government units. Okay. So what was the holding of the Supreme Court? The Supreme Court held that when local governments invoke the power to tax a national government instrumentality, such power is construed strictly against local governments. There is no point in national and local governments taxing each other unless a sound and compelling policy requires such transfer of public funds from one government pocket to another. But the only exception is when the legislature clearly intended to tax the government instrumentalities for delivery of essential services, delivery of essential public services for sound and compelling policy considerations. And there must be express language in the law empowering local governments to tax national government instrumentalities. But with respect to any doubt is resolved against local government. Okay. Now for the last part of part 1 of this lecture, we go now to labor laws and social legislations. So, you know that when you say labor laws, these govern labor standards, employer-employee relations, as well as compensation, benefits, grievances, grievance procedure, termination, dismissal, and many other issues under labor law or the Labor Code of the Philippines. And for social legislation, as I read in the book of Ungos in Agrarian Law and Social Legislation, there is really no exact definition of what social legislation means. But If I were to give it meaning, I would give it as legislation or statutes which promote social welfare and social justice for the people. And speaking of social justice, I think this is um, a very timely recall of what you learned in Kalalang versus Williams, penned by Justice Laurel, about social justice. So Justice Laurel said that social justice is neither communism, nor despotism, nor atomism, nor anarchy, but the humanization of laws and the equalization of social and economic forces by the state, so that justice in its rational and objectively secular conception may at least be approximated. He also said that social justice means the promotion of the welfare of all the people, the adoption of the government of measures calculated to ensure economic stability of all the competent elements of society through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community, constitutionally, through adoption of measures legally justifiable, or extra-constitutionally, through the exercise of powers underlying the existence of all governments on the time-honored principle of salus populi est suprema lex, or the voice of the people is the supreme law. So this is very timely. But I will not go into that, okay? So to continue, okay, in the Labor Code of the Philippines, particularly Article 4, the Labor Code is Presidential Decree 442 or PD 442. In Article 4, it provides that all doubts in the implementation and interpretation of the provision of the Labor Code, including its implementing rules and regulations, shall be resolved in favor of labor. Okay. For social legislation such as the Workmen's Compensation Act, liberal construction is given or applied in order to fully carry into effect its beneficent provisions. Thus, there are laws that should be construed fairly, reasonably, or liberally, and all doubts as to the right of compensation should be resolved always in favor of labor, and all presumptions indulged being in their favor. Okay. For example, in the case of Bautista versus Murillo, in this case, Murillo filed a claim for compensation with the Workmen's Compensation Commission against Bautista. Okay? This arose from an injury while he was employed under Bautista, but Bautista resisted the claim on the ground, among others, that Murillo cannot be considered an employee within the meaning of the Workmen's Compensation Act because it was found that Murillo was not a regular employee and he only volunteered to help and is in effect a casual employee of Bautista. But in this case, the Supreme Court held that while Murillo is a casual employee, he actually worked in the construction of the building which was being undertaken in connection with the business for which Bautista was then engaged. So as a casual employee engaged in the business of the employer, the court held that Murillo is still considered as an employee of Bautista and is still covered by the Workmen's Compensation Act. Okay. So we end our part 1 of the rules of construction on specific statutes. So we will continue with part 2, rules of court, adoption laws, and constitutional construction and local government or local statutes, local autonomy next week. So have a good day, everyone. God bless you all. And always remember, glorify God with a grateful heart. Thank you.